The following program, offered by Fox 19, includes lawyers licensed in Kentucky. For those lawyers to maintain compliance with the Kentucky Bar Association requirements, the phrase, "This is an advertisement," must appear on the screen. Moore Law is underwritten in the public interest by the Moore Law Firm, a legal professional association. This is Moore Law on Fox 19.
Welcome to Moore Law. Today our topic is fighting the insurance company. Insurance companies have access to top attorneys when determining how to settle a claim. If you feel your insurer isn't playing fair, it might be time to seek some legal advice of your own. Has your insurer encouraged you to sign a quick settlement for your accident claim? Have they canceled your policy or raised your premiums after you got sick? Has your legitimate claim been delayed or denied? If you are tired of fighting the insurance company, give us a call at 513-421-4691. The phone lines are open now. Let's take a look at some of the things we have coming up over the next few weeks. Let's see, on October 1st, bankruptcy, October 8th, elder law, and October 15th, we'll be talking about medical malpractice. Here with me today and every Monday, Don Moore. How are you this morning?
Hey, Deb, I'm doing great. How you doing?
Good weekend?
Yeah, I mean, a great weekend from a sports standpoint. Reds clinched the division, Bengals won. We're getting to be a first-class sports city.
That's all anybody was talking about at the gym this morning was a little baseball and football.
I love that, and I also love today's topic. You know, I don't know if you knew or not, but I was an insurance adjuster for about 6 years as I put myself through law school. So this is something that's near and dear to my heart, and we have a very good friend, Joe Ordzansky, with us today. Morning, Joe.
Good morning.
Thanks a lot for coming.
Sure.
Joe is a very experienced insurance professional. He handled insurance claims as a supervisor for more than 40 years, just recently retired.
And enjoying it, you mentioned.
Yeah, that's right. And he went to X University here locally, played for their football team, lived in Cincinnati for most of his professional career, originally from Cleveland. I am really glad you're here. You know what goes on in insurance companies, don't you?
I've been doing it for 40 years, so I have a pretty good idea.
I'll bet you do. I know you do, as a matter of fact. That's great. One of the things today that I want to make sure that we talk about is how people can make insurance claims, or should they make insurance claims on their own. And Joe is going to be able to tell us, answer people's questions, but also as we go along, give us tips on how people should deal with their insurance company when they have a claim.
Okay. All right, great. Well, let's get started. The phones are ringing here, so let's get started with, I think it's Evie in Cincinnati. Evie, you had a problem with raccoons in your house. You paid out of pocket to have it fixed, is that right?
Yes.
Tell us a little bit about what happened then.
Okay, I paid out of pocket. The insurance adjuster came out and looked and told my contractor to go ahead and proceed with the work. We didn't know that it had done damage until he put chimney caps on and almost fell through. And after I went on it and had him do, then the insurance company sent me a letter and said they weren't going to pay.
What would be her next step then?
Well, unfortunately, raccoon damage is excluded, I think, under some policies, some homeowners policies. So it's considered a maintenance item. It's something that a homeowner is responsible for themselves.
Do those things come up a lot? Because I think, I've gone to file claims myself, and I'm told that, that's not covered by your policy, and it's frustrating.
Well, certainly it's frustrating. There again, though, it's an insurance contract. And if the contract says coverage applies, then it should be paid. If it's not covered, then it shouldn't be paid.
So Joe, there's different kinds of policies, aren't there?
Oh, absolutely.
So there's a thing called name perils. That
Right.
is where you get 11 or 15 different things that are specifically covered, like fire and water damage and windstorm, things like that.
Correct.
And then you also have
An all-risk policy.
All-risk policy. Thank you. Why don't you just tell us what an all-risk policy
Well,
is?
it covers the property against all risk of physical harm, except for those items that are excluded.
Right.
And there are always exclusions in a homeowner's insurance policy. Certain things that are considered maintenance items for a homeowner are not covered by the insurance company.
So damage from a raccoon would not be considered a casualty loss?
That's correct.
Okay. All right. Good to know.
All right. Now I know.
Sorry, Evie.
Sorry about that, Evie, but we now have Russell. Russell in Cincinnati, go ahead.
Yes, call regard. I was involved in an accident and just purchased a used car from a dealer, had a legal contract, and have legal insurance. Person hit me in the rear. They was found at fault. Who would be the one to be able to sue for damages to repair my car?
Your thoughts for Russell?
Sounds like a legal question to me.
Well, and
There's a
Russell-
contract involved, so
Russell, I got the part where you bought a used car, and there's a little break in there that I missed. Could you fill me in a little better, please? Okay.
Did we lose Russell?
I think we lost
I think we
Russell.
did. You know what? Why don't we take a break and we'll be back talking about fighting the insurance company. Give us a call, 513-421-4691.
Welcome back to More Law on Fox 19, your legal questions live, with local broadcaster and award-winning reporter Deb Haas and Cincinnati personal injury attorney Don Moore, recognized by Ohio Super Lawyers. More answers, more help, more law on Fox 19.
Welcome back. It's time now for More Law Connection, where Dan Moore is answering viewer emails. Good morning, Dan.
Morning, Deb. Today, our first question is from Frank. He asked, is it necessary to get the police to come out to a minor fender bender if the people involved give each other insurance information? Now, this is something that is one of those things that there's something you have to do and there's something that you don't have to do. And when you have a minor fender bender, you don't have to call the police. If you're not injured, both parties stop and exchange insurance information. However, it's not something I recommend. So even though you don't have to, I wouldn't do it. Because if you're the person who wants to recover because the other person hit you and it's their fault, then you want the police to be called, you want the police to fill out a report, you want the police to determine whose fault it is so that you can submit that report to the at-fault insurance company later on, and then there's going to be a lot less likelihood for the person who's at fault for the crash to come back and say, no, it's your fault. So that police report is very valuable, and you got to call the police to get it. Back to you, Deb.
All right, thanks a lot, Dan. We are back talking about fighting the insurance company. Our guest today, Joe Orodzansky. Thanks for being here.
it's good to be here.
You know, we're calling it fighting the insurance company. Does it have to be a fight?
No, absolutely not. As an insurance adjuster or the insurance company, it's a job. It's an industry that needs to cooperate with the people that we deal with in order to satisfy the requirements of our contract. So it's not a fight. Sometimes there's some disagreements as to value or timeliness of things of that nature, but it shouldn't be a fight. It should be a cooperative effort. There are a lot of attorney firms that I, as an insurance adjuster, have had to work with who are very well versed at what's needed by way of the insurance contract and cooperate fully in providing the information needed to allow us to evaluate claims. Without that cooperation, it becomes a long, drawn-out affair.
Because it is people dealing with people. So, I
Absolutely.
mean, it's your attitude can make a difference.
Sure. And if you go in with a good attitude, trying to work with or along with the adjuster or the insurance company, you'll probably have a good result. If you go in with a negative attitude, you may end up with a negative result.
Okay. All right. Life lessons for everybody. Let's go to the phone now. Let's see. Ozelia in Cincinnati. Ozelia, you and one of your grandchildren were involved in an accident. You were pedestrians, is that right?
Yes.
Can you tell us a little bit about your call?
Yes. I was going to the store and I was passed by Walgreens in a parking lot. The guy told me to go ahead and he hit us anyway.
So you were walking in front of the car and he hit you after, and he had said to go ahead?
Yes, he told us. I stood there and he told us to go ahead, and then he hit us with the car.
So Azalea, were you injured?
Yes.
And how about you had one of your grandkids with you?
Yes.
And were they injured also?
Yes.
Well, actually, there's a couple of things. One is a pedestrian, you may or may not know it, but if you have auto insurance, your own medical payments coverage from your car insurance may help you right in the very beginning with your medical bills. That's something a lot of people don't know. The other thing is, obviously, if there is negligence on the part of the person who hit you, and it sounds like if they waved you ahead and then they hit you, probably is negligence, then you should make a claim against their insurance company. If your injuries are minor, then that may be something you can handle on your own without an attorney. If you have significant injuries, like you had extended hospitalization, large bills, or they deny coverage, then you're going to need help. And then that's when you should talk to an attorney and get help.
Okay. All right. We hope that you're doing better, Azealia, there as well. Now we want to go to Margaret. Margaret, you also have a question about car accident.
I was involved in an auto accident where I was hitting the rear of my car. The insurance company that they have has not paid me anything. And I have to pay out of my own pocket for medical expenses relating to this accident. And it's causing me a lot of financial problems right now. And I'd like to know legally what I can do.
Okay. Joe?
Well, first and foremost, if you know who the at-fault party is and who their insurance carrier is, you should try and contact them. I expect you probably already have. The other aspect of it is under your own policy, you do have medical payments coverage that should be able to at least take care of the initial bills and treatment that you've received for your injury. And of course, if you have collision coverage, you can handle, or your property damage can be handled under your automobile coverage also. But by all means, you need to follow up with and try and obtain information on the at-fault driver, their insurance carrier, their coverage, so that they can either pay your company back or pay you direct for your damages.
Don?
So Margaret, one of the things you also need to know is that the insurance company for the at-fault person is not going to give you any money until you sign a release. So what that means is basically don't count on them paying any of your bills or any of the other things, wages, any of those expenses, because until they get a release, that is you sign and forever say they bought their piece, and for the total settlement, they're generally not going to make any payment. So what Joe talked about just a minute ago about medical payments, sometimes that bridges the gap. And you can use your medical insurance to cover your medical bills, and you should submit the claim to the medical insurance company if you've got one. And you should submit a claim to MedPay. That's what you pay your premiums for. If they make a payment directly to you, that can help bridge the gap between the time of your injury and the time you actually settle with the at-fault party.
All right. Let's go back to Dan Moore with another email question. Dan?
Okay. Our next email is from Jen. She says, my son broke his leg after falling off our swing set. When I looked, I noticed one of the bolts on the swing had broken. Do I have a claim against the manufacturer? The answer is maybe, like a lot of legal questions. Let me give you 3 pointers that will help you out here. The first one is make sure and preserve that bolt. You got to preserve the evidence. If you don't, then you won't have a case. Number 2 is take a look at that bolt and make sure the bolt was used properly. If it wasn't used in the correct application, then you probably don't have a claim there as well. The third thing to take a look at is to see if that bolt was the actual cause of the injury. So, in other words, was it another kid that pushed your son off? Was it something else in the swing set that would have caused the injury? If the bolt was the item that caused the injury, then you likely may have a claim against the manufacturer. Now, if you have a question, go to fox19.com, click on the More Law button at the top of the page, and fill out the Send Us Your Questions form and click Submit. We will do our best to answer your questions. Now, that's all I have for today. I'm back to the office. Deb?
Thanks a lot, Dan. We are going to take a break right now. Give us a call if you have a question about fighting the insurance company. 513-421-4691.